Mr. Foreman and members of the jury, at the close of the plaintiff's case, counsel for the defendants made several motions to dismiss the complaint, and again at the end of the entire case, counsel for the defendants made motions for direction of a verdict in their favor. You will remember that all of those motions were denied by me. From the denial of those motions, you must not, however, infer that the court is of the opinion that the plaintiff should succeed. Those were rulings on questions of law to the effect that, in my opinion, a question of fact was involved. My duty under the law is to submit to you for your determination all questions of fact which arise in any case, and I am going to submit what I believe are the questions of fact involved in this case for you to decide. The plaintiffs, a husband and wife, each bring an action against these defendants, claiming that through the carelessness and negligence of the defendants, the plaintiff wife met with an accident, and she brings her action to be compensated for her pain and suffering. The plaintiff husband brings his action to be compensated for monies which he claims he was compelled to expend due to this accident and compensation for the loss of the society of his wife. The plaintiffs in both cases claim that these defendants constructed and permitted to remain and maintained in an unsafe and dangerous condition a certain temporary platform which had been constructed by the defendant. The defendants deny the plaintiff's claim. The witnesses that have been called have explained to you the condition as it existed at that time. The plaintiff wife claims that after she left her home, she proceeded north. Then she turned to the right and proceeded in an easterly direction on the southern side of 163rd Street. She claims that while she was walking along 163rd Street, which she claims was very dark at that time, that her foot caught on some wooden structure on the sidewalk, causing her to fall, as the result of which she sustained a fracture of the right ankle. That is the plaintiff's claim. The defendants do not dispute the injuries which this plaintiff received, but do dispute the liability on the part of either of these defendants. So that the first thing for you to determine, having found what condition did exist at that time and place, is whether or not a dangerous condition existed at that time on that sidewalk. If you find that there was a dangerous condition there, then the second issue for you to decide is whether or not the plaintiff wife, in passing in the manner which she did, used the care that she should use under the circumstances and conditions as they existed at that time. In the husband's case, you would award him such an amount as you think will compensate him for his damages, hospital bills and doctor's bills, and hiring of housemaid and so on. On the other hand, if you find that either the plaintiff was herself guilty of negligence in the manner in which she walked along this street under the conditions as they existed at that time, or if you find that there was no dangerous condition existing at that particular place at that particular time, then the question of damages should not be considered by you, and your verdict should be for the defendants. Photographs of the platform as it existed at that time have been received in evidence known as Plaintiff's Exhibits 1 and 2. You will notice that a portion of those exhibits that have been omitted and cut out by agreement of counsel, that gives you a fair idea of the platform which had been constructed at that time. The plaintiff claims that this platform was some 4 or 5 inches high at the west end and some 12 inches high at the easterly end, and that it was some 8 or 9 feet long by some 5 feet wide. The defendants claim that this platform was but 3½ inches high at the westerly end and some 6 to 7 inches high at the easterly end, and that it was some 14 or 15 feet long and projected out about 6 feet from the building line. As I said, from the testimony which has been given to you by the witnesses and by the photographs which have been received, you will find, first, whether or not a dangerous condition existed there. It is not a question as to whether or not either of these two defendants might have constructed something other than what was constructed. The question is, was it a dangerous condition? The defendant, in constructing this platform, owed no greater duty than did the municipality. The plaintiffs bring the suits, and bringing the suits, they must establish what is known in law as the burden of proof. And by the burden of proof is meant that before you can find in their favor, you must find that there is more evidence in favor of their contention that you credit and that you believe than you find opposed thereto, before you can find in their favor. While doing that, if you find that the credence is evenly divided on any question of fact which is involved, you must decide that particular question of fact against the plaintiffs and in favor of the defendants, because in that event the plaintiff will have failed to satisfy you by the burden of proof which the law casts upon them. In doing that, keep also in mind that quality rather than quantity of testimony is to govern you. In deciding this case, take also into consideration the interest that any of these witnesses may have as to the result of your verdict, the probabilities of their testimony, and then to the testimony you will give the weight and credit you find it is entitled to. If you find that any witness has willfully sworn falsely, your duty is to disregard that statement. Get that?